U.S. Marshals are moving as we speak. Judge Eleanor Caldwell has just signed off on arrest warrants for multiple people after the explosive leak of what's already being called the Witness 14 tape. For the first time in this entire investigation, a federal judge has ordered immediate custody based on recorded testimony that was never meant to be public. Sources inside the courthouse describe absolute chaos. Lawyers sprinting between chambers, phones being seized, marshals posted at every single exit. This is not a procedural motion. This is not a stalling tactic. This is a sitting federal judge saying, "What I heard on that recording is prima facie evidence of serious federal crimes," and demanding that people be in custody before sundown. So, what exactly triggered this kind of reaction? A 47-minute recording from a protected witness identified only as Witness 14 leaked online late Thursday night. Within hours, it had been viewed or downloaded more than 2 million times before platforms scrambled to rip it down. This isn't just the latest scandal in a case already flooded with scandals. Legal analysts are calling this tape the smoking gun. Direct recorded evidence of coordinated criminal conduct that names specific people, cites exact dates, lays out illegal transactions in detail, and I have the breakdown of what that recording contains. What makes this unlike any other leak in recent legal history is how Judge Caldwell responded. She didn't simply order an internal probe. She didn't set a hearing 2 weeks out. She verified the tape's authenticity and within 6 hours issued federal arrest warrants. Former prosecutors are saying they cannot recall another modern case where a judge moved this fast on the basis of a leaked recording. The warrants reportedly list individuals no one expected to see in handcuffs. At least not this early, and not like this. The marshals handling this aren't from a local district. They're federal, acting under direct orders from a judge who has clearly decided she's seen enough. So, what does the Witness 14 tape actually show? According to transcripts now being passed quietly between legal experts and investigative reporters, the recording captures a protected witness describing a deliberate coordinated operation to obstruct justice, tamper with evidence, intimidate other witnesses. This is the core of the story. Witness 14, whose identity is still sealed by court order, says they were personally instructed to destroy documents, alter digital records, coordinate false testimony with at least 4 other people. The tape references specific dates March 14th, April 2nd, and May 19th of this year. It identifies 3 previously unnamed co-conspirators and describes cash payments totaling over $340,000. Allegedly used to buy silence from potential witnesses, legal analysts who've reviewed authenticated portions say it's the level of detail that makes this so devastating. At one point, the witness reportedly says, "I was told exactly what to say. They gave me a script. When I asked what would happen if I didn't follow it, they made it very clear my family would face consequences." This wasn't witness preparation. This was witness tampering. Prosecutors are already characterizing this as obstruction on a scale that fits a racketeering make. It goes further. The tape reportedly includes a description of a meeting where the How Destruction of Evidence Act was openly discussed. Witness 14 recounts documents being shredded, hard drives being physically destroyed, cloud backups being systematically wiped, all while the investigation was already live and subpoenas were outstanding. Former federal prosecutor Marcus Webb told the Daily Beast that in 3 decades of practice, he's never seen obstruction documented this cleanly on tape. The witness doesn't speak in vague terms, he said. They give badge numbers, physical locations, direct quotes, banking details, and even the names of attorneys allegedly involved. It's surgical. And then there's the part that has shaken even veteran observers. In the final segment, Witness 14 reportedly describes threats directed at their own children. According to the transcript, the witness says photos of their kids' school were texted to them along with a message that read, "Testimony has consequences." Professor Danielle Reeves of Georgetown Law points out that this shifts the case into an entirely different category. Threatening a witness is obstruction. Threatening their children is high-grade witness intimidation, a separate federal felony that often carries enhanced penalties. The full recording runs 47 minutes. Experts say roughly 31 minutes are direct substantive testimony. The rest is questioning by the interviewing attorney. The audio quality, by all accounts, is crystal clear. No obvious edits, no gaps. Multiple independent analysts have now confirmed the voice matches prior verified audio of the witness. The metadata lines up with the date claimed. References in the recording to external events match up with documents and timelines from the case. Sources say Judge Caldwell personally watched the tape twice before acting, pausing only to confer with her clerks about which statutes applied. Those who've heard the audio say the written transcripts don't fully capture it. The fear, the exhaustion, the sense of someone who knows they are risking everything. One journalist who obtained the full recording described it like this: "It's 47 minutes that could redefine not just this case, but how we talk about obstruction of justice in this country." If you're following this and want the real analysis as it breaks, hit subscribe and turn on notifications. This story is moving by the hour and mainstream coverage is behind. Now you know what's on the tape. Let's rewind and look at how we got here, because that context makes the leak and the judge's reaction even more explosive. This case has been building for more than 2 years. It began as a relatively contained financial probe. Over time, it widened into what prosecutors now describe as a sprawling criminal enterprise involving fraud, corruption, multi-layered obstruction efforts across different jurisdictions. Tensions have been simmering for months. Repeated delays, sealed motions. 3 earlier witnesses abruptly forgetting key facts on the stand. A creeping suspicion among legal observers that the case was slowly being strangled by procedure. Everything pivoted on October 3rd, when Witness 14 officially entered protective custody. Court filings show that Witness 14 was an insider, someone directly involved in operations who originally cooperated with the ME defense before flipping and working with prosecutors. Within 48 hours of that flip, the government moved the witness into protection, citing credible threats. For months, their recorded testimony was locked down under seal. Defense lawyers filed in 17 separate motions seeking access. 17 times Judge Caldwell said no, citing an active threat environment and the witness's protected status. This wasn't about tactical secrecy, it was about safety. Then on November 8th, the defense played their own card, an emergency motion accusing prosecutors of coercing Witness 14's testimony. Judge Caldwell scheduled an evidentiary hearing for December the 2nd. It never happened. On November 29th, the tape leaked. First, snippets appeared on encrypted channels. Within hours, the full 47-minute audio hit multiple hosting sites. By midnight, it had spread beyond any realistic chance of containment. At 6 Ma the next morning, Judge Caldwell convened an emergency session. People in the courtroom say she was visibly angry, not at the witness and not just at prosecutors or defense, but at the fact that a protected, sealed recording had been dumped online. "The leak itself is a federal crime," she reportedly told the assembled attorneys. But what this recording reveals are crimes of far greater magnitude. By noon, she had signed the arrest warrants. What makes this moment unique is not only the severity of what's alleged, but the quality of the documentation. Obstruction cases usually rely on circumstantial patterns, contradictory statements, forensic reconstructions of destroyed logs and emails. Here, prosecutors have something they almost never get: a protected witness on tape walking through the scheme in real time with dates, names, amounts, and instructions. At 11:47 a.m., Judge Caldwell took the bench for that emergency session. Lawyers on both sides had been ordered to appear with just a few hours' notice. Some were still buttoning jackets as they came in. Others hadn't slept. No public gallery, no media, only essential staff. Reporters outside the courtroom described an eerie stillness. Then they saw marshals redeploy from outer corridors to every interior entrance. Inside, when Judge Caldwell finally spoke, those present say the room went dead quiet. "I have been on this bench for 22 years, she began. "I have never seen evidence of witness intimidation. This explicit, this organized, or this contemptuous of the authority of this court." She then read out the names: 4 individuals, warrants signed, sealed, and now being executed. When she finished, she turned toward the defense side. If any officer of this court had knowledge of these activities and failed to report them, She said they should consider their own legal exposure very carefully in the coming days. Two defense attorneys immediately tried to withdraw from the case. She denied both motions on the spot. It was in that moment that observers realized this isn't a case quietly collapsing. This is a judge drawing a line and enforcing it with the full power of the federal system. This isn't the first time a recording has blown open a major case. But the speed on of the judicial reaction sets it apart from almost anything in recent memory. Think about Watergate. The Nixon tapes eventually exposed a sitting president directing obstruction from the Oval Office, but it took years of grinding legal battles before they were forced into the open. Access Hollywood 2016. A political bombshell, but not part of any active case. There was no courtroom to respond. The closest legal analog some experts point to is Martha Stewart. Convicted not for the underlying financial crime, but for lying and obstructing. Still, even there, the process moved in months, not hours. Here, Judge Caldwell moved from authenticated recording to active arrest warrants in his 6 hours. Some legal historians are already comparing the dynamic to the Saturday Night Massacre of 1973, when attempts to kill the Watergate probe backfired and accelerated Nixon's downfall. In each of these historic moments, the pattern is the same. The cover-up becomes the real crime. There's a clear through line. When recordings surface that capture criminal behavior in detail, the obstruction and intimidation that follow can eclipse the original offense in severity and consequence. What's new now is a federal judge treating that obstruction not as an accessory charge to be sorted out eventually, but as an urgent emergency requiring immediate forceful intervention. Former U.S. Attorney Pitt Barrara said, "Judge Caldwell's move is exactly what courts are supposed to do when the core process of justice itself is under attack. When you have active threats to witnesses and ongoing destruction of evidence, every hour you wait is an opportunity for more harm." The judge understood that to preserve the case, she had to act at once. Constitutional scholar Lawrence Tribe has pointed out that yes, the leak itself raises serious legal issues, but that doesn't neutralize what's on the tape. The method of disclosure doesn't erase the substance. Tribe noted the leak is a crime. The conduct described is a crime. The judge is obligated to respond to both, but the acts described on that tape pose the more immediate threat to justice. Others stress that whether or not the tape was properly handled in its journey to the public, the judge is basing her emergency actions not just on the leak, but on her own in-court review of the evidence and the broader pattern of behavior in the case. Criminal law expert Rachel Barrow emphasized how serious the threats to children are. In particular, threatening a witness's children moves this out of the realm of hardball tactics into something approaching terror. The federal system treats that as an aggravator that can significantly lengthen sentences. Even commentators who often argue for more cautious, slower judicial responses have largely supported Caldwell's decision as necessary in this context. Harry Littman, a former DOJ official, put it bluntly, "In a perfect world, you'd prefer to move methodically. This isn't a perfect world. You have someone under protection whose kids are being targeted and evidence that's actively disappearing. Waiting for the right time means watching the case fall apart." Judge Caldwell is known above all for being cautious, and by the book she's not a showboater. The fact that she chose to move this fast tells you exactly how grave she believes the situation is. The immediate consequences for those named in the warrants are enormous. Under federal law, obstruction of justice can carry up to 20 years per count. Witness tampering can add another 20. Threats against a witness's family are separate felonies with enhanced penalties if prosecutors can show that multiple people acted in concert. RICO racketeering theories could multiply the exposure further. On top of criminal penalties, there's career fallout. At least 2 attorneys have already tried to withdraw. Bar associations in multiple states have opened ethics inquiries. Any lawyer found to have facilitated or ignored this scheme is looking at potential disbarment and criminal charges of their own. But the impact doesn't stop with this case. Judge Caldwell may have set an informal template for how federal courts deal with clear, credible evidence of witness intimidation, ongoing evidence destruction, coordinated obstruction. Historically, courts have handled these issues methodically, slowly within the usual procedural timeline. Caldwell's message is different. If you try to strangle a case in real time, the court will not sit and watch. In other words, the judicial branch still has teeth. The defense response so far has only made things worse. Within hours of those warrants being announced, counsel for one of the named defendants issued a statement blasting Judge Caldwell's move as a grotesque abuse of power driven by illegally obtained evidence. Notice what's missing. They didn't deny the meetings happened, deny the payments were made, deny the threats were sent, deny the existence of scripts for false testimony. They attacked the War League Curry, not the Hood facts. Communications expert Kathleen Hall Jamieson summed it up. When all you can talk about is how evidence surfaced, not whether it's true, you've essentially conceded its truth. Meanwhile, the others named in the tape have said nothing publicly. Their lawyers have declined comment. No one has stepped forward with an alternative account of the dates, payments, or threats. That silence is telling beyond the legal chessboard. Here's what this really comes down to. Can powerful defendants corrupt judicial proceedings and get away with it? Can witnesses who risk everything to tell the truth trust that the system will protect them? Witness 14 didn't leak this tape. They did what the system asked, came forward, entered protection, told their story under oath. Someone with access to sealed materials betrayed that trust and put them and their family at greater risk. But in doing so, they also exposed a pattern of obstruction the system had not yet managed to fully stop. If nothing was done now, the message to future witnesses would be devastating. We can't keep you safe. If you cooperate, you're on your own. Judge Caldwell made a different choice. Her actions say obstruction will be met quickly, not just eventually. Threats against witnesses and their families cross a line the court will enforce. The justice system still has the capacity to defend itself when it chooses to. This doesn't just affect the people on this tape. It affects anyone who might ever have to rely on the legal system to work in a moment of crisis. And for the first time in a long time, it looks like that system is remembering how to move. As of right now, 2 of the 4 individuals named in the warrants are in custody. A third was taken into custody at a private airstrip about 90 miles from the nearest international border, with 3 suitcases and more than $40,000 in cash. The 4th remains at large, and marshals have put out a public advisory indicating they may have fled the jurisdiction entirely. Federal agents are coordinating with overseas counterparts. This is no longer a local story. Witness 14 has reportedly been moved again to a new, more secure location. Their protective detail has been expanded. All non-essential communication has been cut off to reduce exposure. The tape, despite takedown attempts, is effectively everywhere. Jurors across the country have likely heard at least portions of it. Venue fights are all but guaranteed. Finding a truly untainted jury pool may be impossible. Judge Caldwell has scheduled an initial appearance and arraignment hearing for 9:00 a.m. tomorrow. Prosecutors are expected to argue for detention without bail, citing, documented threats, evidence of attempted flight, risk of further obstruction if defendants are released. That hearing will tell us a lot. How seriously the court views the ongoing danger, whether any defendant is considering cooperation, whether more explosive revelations may be coming from inside the circle. The next 48 hours are critical. This is the moment where we find out whether this is the start of real accountability or just another dramatic spike in a case that ultimately sinks under its own weight. For now, a protected witness has risked everything. A federal judge has responded with maximum force. And the marshals are out executing orders right now. If you want to follow every step of what happens from here, bail hearings, plea negotiations, new filings, make sure you're subscribed with notifications on. Tomorrow's hearing could fundamentally change the trajectory of this case. I'll be here to break it down for you piece by piece. I'll see you in the next update.